The Lawyers Club of LA County is very happy to have George Finder speaking today for our program. Mr. Finder has over 15 years experience in the world of credit counseling, credit debt counseling, and can speak to a new area of damages that a lot of lawyers don't know about, or if they have found out about it, they're not exploiting it properly. So, without further ado, Mr. George Finder.
Hello. Thank you, Jim. My name is George Finder, and I'm going to talk to you today about credit damage, a form of economic damage that is compensable with a proper organized foundation for a damage demand. And that's what we're going to talk about. We're going to talk about credit damage as increased out-of-pocket costs. We're going to talk about it as loss of accounts, credit accounts that you have, and those accounts are lost because you're not paying your bills, because of the defendant's actions. And last but not least, the inability to get new credit is the third form of compensable credit damage. So with those three, we are now going to talk about how to identify a credit damaged client and what to request out of that credit damaged client at intake. One of the things that I suggest very strongly the office include in their intake session is an aspect that will identify a credit damaged client. It's a single page of questions that can be modified to suit your office. The point is to get the lawyer and to get the plaintiff, client, thinking along the lines of what is my damage, what can I be compensated for, and can we prove who did it? Well, proving it is up to the lawyer, but I am able to use standard credit industry documents to establish a foundation for the demand. Those documents can include monthly statements on credit card accounts, on mortgage accounts, any special notices that are issued by the creditor during the damage period. Credit cards, of course, are monthly statements, and the credit card statements are usually the way the notices of a change in interest rate or a change in credit limit are communicated to the card holder. Credit card companies like to do things as cheaply as possible, so they include it in the monthly statement. Mortgage companies don't. They will send you a special notice. Other credit cards, other creditors will typically send you a special notice. If it goes to foreclosure or collections or other court-involved activities, you will get separate and distinct notices from whichever aspect of the court is appropriate. Collecting those notices, collecting those monthly statements are the simplest way to document what happened and when it happened and who did it in terms of credit, not in terms of the litigation, but in terms of the damage that was caused. The other document that is very, very valuable to the attorney and to the expert is the subscriber credit report. The subscriber credit report is not what you normally get if you get on the internet and you request a credit report. That free credit report is called a consumer disclosure credit report, and that report has no legal recognition and is not accepted ever for application review of employment or credit or insurance where that's appropriate by the issuing or granting company. Only kind of credit report that they will review or look at is a subscriber credit report. The subscriber credit report is not written in plain English. It is written in codes. The codes take some time to learn, but they're not that difficult. the Consumer Disclosure Report, which is written in plain English, as required by law, has less information in it, in more pages, and based on two studies, one by the Public Interest Research Group in 1991 and another one done by the Wall Street Journal in 1996, the error or difference in the information contained in the two kinds of reports can be as high as 48%. And that difference is either missing information or different information. And the Public Interest Research Group used the language that the mistakes that they included in their calculation were the kind of mistakes or omissions that would cause denial of the application. It's not that your middle initial is missing. It's not that your employment has changed or your address is transposed. It's a significant enough omission or misinformation that you will be denied. Now, if the information is either not there or wrong, then the foundation for the damage claim is frivolous or speculative or worse, whatever the right legal language is. So it's vital that the attorney expecting to use a credit report as part of the testimony of the expert be sure to obtain the correct kind of credit report. And again, I want to say that's a subscriber credit report. Now, most subscriber credit reports, but not all, come in a tri-merged form. And what that means is you get all three credit bureaus in one report. You don't have to get three different reports. You can also get the Consumer Disclosure Report tri-merged, but it's more paper that is not to your purpose. So a subscriber tri-merged credit report with a credit score is the best kind of credit report to get. If you go to the credit bureaus, they will not sell you a subscriber report unless you are a subscriber. If you go on the internet, there are over 1 million websites that offer you a free credit report. Depending on the purpose of your wanting to know what's in your credit report, if you're mildly curious and you just want to see what might be going on, the Consumer Disclosure Report might be useful. Personally, I don't think it's worth anything except an income source for the credit bureaus. Stick to the subscriber report. It's the most reliable, most accurate, most complete information that will be useful to the case, the matter at hand. There are two ways to get a subscriber credit report. One is go to a lender. Tell the lender that you would like to be pre-qualified for a loan. And we'll hope that when you tell that to the lender, there is some truth in that. The lender has the right to charge you for that credit report. And if you are charged for that credit report, you are legally entitled to possession of that credit report. If he gives it to you or the lender gives it to you, it's an option. It's at the discretion of the purchaser of the report. So that, the other way is to contact me, and I will talk to you about how we can get it. So that's the issue with credit reports. Now let's talk about credit demand. Building the foundation for testimony by an expert, which is required in order to present a credit damage demand, starts with the intake sheet that I mentioned a few minutes ago. That is what will start us down the path of collecting and identifying a compensable from a non-compensable credit damage client. There are some very simple preliminary questions that can be asked to eliminate the unqualified client. And one of those situations is insufficient use of credit. If the client does not have at least $15,000 of credit of any kind. Credit cards, gasoline cards, department store cards, any of those, and possibly including a car loan, there is not sufficient credit damage to be compensated. The variable to that is if the person is very young. If they're just starting out in life and they have not had a chance to build their credit portfolio, and it's damaged when they're a teenager, they're in their early 20s, maybe even their mid-20s, that does not automatically disqualify them, but it certainly raises a consideration to be analyzed. It is best to have clients who are credit damaged, who have real estate experience, who have purchased a home, who have been foreclosed on a home, maybe as a result of this litigation, maybe prior. You want to make sure that the credit that is in consideration is recent enough. What somebody did 7 years ago has absolutely no bearing on their creditworthiness today. Credit information that's over 2 years old is not practical for litigation compensation purposes. The credit report that I have suggested that be pulled, which is the subscriber credit report, contains information going back 7 years on creditor accounts. Those accounts are, again, department store, MasterCard, Visa, MasterCard, Discover, American Express. All of those accounts can go back 7 years from the date of last activity. Public records can remain in the credit report for 10 years because they are required to remain in the public record and available to anybody who wants to look at it for that duration. The credit bureaus have opted to avail themselves of that information because credit bureaus learn that bad news sells better than good news. Lenders are always looking for good news, but they base their decision on the quantity of bad news. The more bad news you have in your credit report, the less likely it is that there's going to be good news at the end of the case, unless it's as a result of the damage that the litigation is about. If the client has recent credit usage in a sufficient amount, then it makes a lot of sense to include credit damage as a component of your damage demand, economic damage demand. There are questions that are very simple, that are generally misunderstood by the law office as well as the client. And I'm going to go through some of those briefly. Again, I want to, this form is available to you to download off the internet. This form can be modified to suit your office temperament so that you get what is needed by the expert and what is comfortable for your office. So let's start with what we're going to ask. The first question we're going to ask is, what's the type of credit-related injury or injury period? For instance, this could be a personal injury case that we're dealing with. Is it an auto accident, a truck, a motorcycle? Is it a slip and fall? What is it? That's not important as to the use of credit, but it's important because there is special special legal considerations in different states that need to be addressed. Credit damage is not acceptable as a compensable damage in all forms of litigation. In Washington State, you can collect credit damage in every kind of tort except personal injury. The insurance lobby made sure of that. Okay, so if there's an injury, and we're going to use the personal injury example here, was there lost time from work? It is common for serious personal injury, as opposed to a scratch on the car or whatever, for there to be lost wages, and most law offices expect to recover some lost wages for their client. one of the red flags that should go up is if the lost wages exceed 8 weeks, 4 pay periods typically, it is 99% certain that they are not able to pay their bills, and because they're not able to pay their bills, their credit has been affected by the non-payment of bills due to loss of income. So it behooves the law firm, in recovering lost wages, to ask the question, what's your credit like as a result of not being able to pay your bills? And if that can be answered to the satisfaction of making compensation, then that becomes very valuable to the case. Because the damage to a credit reputation is able and probably will last for 7 years. Because if that late payment is on the record, the law permits it to be reported for 7 years from the date it was late. Doesn't make any difference when the account was open. Doesn't make any difference if the account is closed. That information is permitted to remain in the credit report for 7 years. The damage period is dictated by that same information. You cannot collect 30 years of excessive interest on a 30-year note due to credit damage, because in 7 years that information will either disappear or be replaced by better information, or maybe I should say different information, because maybe it's not so good. So 7 years is the typical damage period limitation, and that damage can be calculated on a yearly basis. When I started performing this expert witness service, my first case was real estate fraud. The real estate agent in Ontario, California, had defrauded his client out of a $140,000 piece of real estate. The seller thought everything went smoothly. She did not realize that the realtor had moved his family in and never made a payment during all the time that his family was living there. And when she went to the bank to purchase a new house within the 2-year period where she could take advantage of tax and other benefits, they pulled her credit report. It's a standard matter of routine. And the lender said, gee, did you know you're in foreclosure? Why did you come here when you're in foreclosure? And she said, I can't be in foreclosure. I don't have any property. And so the loan officer at the bank showed her the report. She recognized the address. She went to her lawyer. The lawyer went to do what lawyers do, and eventually errors on omissions insurance paid for everything except her reputation. Her lawyer happened to attend one of my seminars, similar to this one, but longer. And it was on credit reports specifically. And he asked me, since I was so knowledgeable about credit and credit reports, could I put a value on a reputation loss due to this fraudulent activity? And I said I could, and I did. It took about a year to get to the arbitrator, and the defense vigorously tried to have me declined or denied testimony because I have never worked for a mortgage company. I've never worked for a real estate company. I'm not an attorney. I'm not an accountant. I'm not any of the things that are normally associated with real estate. However, I am an expert on credit reports, and since 1991 have taught licensees of the Department of Real Estate about credit reports relevant to their ability to make a transaction. Mortgage brokers love what I tell them. A year later, the California State Bar recognized the value of that same information. And on the basis of those continuing education presentations, the arbitrator accepted listening to me. He didn't say he believed me, but he did say he would listen to me. And as a result of his listening to me, in what I said at that time was, it is my opinion based on certain information, and I told him what it was, that the damage inflicted on the plaintiff is between $31,000 and $35,000, and I gave him the foundation of that amount. He seemed to accept it because when he came back with a ruling in my client's favor. Prior to that ruling, the insurance company had assured the client vigorously that credit damage was not measurable, that it was impossible to measure credit damage. And that had been the conventional wisdom for many, many, many years. In my opinion, since 1899. Definitely since 1950. In 1970, when the first Consumer Credit Protection Law was passed in California, and that was known as the Fair Credit Reporting Act, for the first time, consumers had the right to know what was in their credit report. And knowing what was in their credit report substantially increased the accuracy of the reports. By making the reports more accurate, loans became more reliable. And by knowing what to look for in the credit transaction, the credit procedures, standard procedures, nothing secret, everybody knows about them, I was able to show the arbitrator that the lenders or the type of lenders that this plaintiff would go to based on her experience and tradition, they would require an extra $20,000 out of pocket from that individual. And in addition to the extra $20,000 at that time, they would raise the interest rate so that on a yearly basis, over a 7-year period, she would pay out approximately another $15,000. The numbers vary from lender to lender, and different lenders have different ways of calculating or amortizing the payout schedule. So it's important that all the information be very specific rather than generic. Based on that concrete foundation of the valuation, and hearing that for the first time, the insurance company raised their offer to settle the case before the ruling came in to $7,500. Prior to that, they had offered her $4,500. The arbitrator came back and ruled in her favor at $33,000, which was exactly in the middle of my two numbers. So that felt pretty good. And as a result of that, here I am. Stop this for just a second. What are we doing time-wise? Ready? Okay. So the question of lost income has repercussions beyond replenishing a bank account, because if the bank account has been depleted and bills have not been paid, the cost of living goes up dramatically. The next question is, ask the client, has the damage, has the loss of income caused you to make late payments? Because I don't want to assume, and I don't want anyone to come back and say, well, did you ask the client if they were late and why they were late? So let's have the client tell us. Then we want to know on this credit damage intake form, are they paying mortgage or rent? And have they been late on those? And if so, how often? Etc. Then we have a list of credit cards. We ask very specific information. Have your credit limits been reduced? Has your monthly credit card payment been increased due to an increase in interest rate? It is not unusual for a delinquent credit card, even with the new Credit Card Protection Act of, I think, 2009 or 2010, for interest rates to go from however low you've been able to start them at 8 or 10 or 12 or 15%, for them to go as high as 30%. And there's nothing you can do about it other than pay off the balance. There's no appeal. It's totally to the discretion of the credit card company. And they fear if you owe them a lot of money, they want to do everything they can to make life more difficult for you, but get their money. What about car payments? Are you current on your car payments? Is your car in danger of being repossessed? All of these things have not only the immediate problem, but if your car is repossessed, there is a whole new ding on your credit report. And it causes another problem. How are you going to get to work? Maybe you can't work. This is assuming that there's no medical reason for you not to be able to work. have your accounts gone into collection? And if so, are you getting calls? Are you getting dunning notices? What's happening? Now, these are not complicated questions, but it always amazes me that the consumer and the lawyer never think about how these affect the value of the compensation. If you get this, you're way, way ahead of the game in terms of being able to collect. I also want to add, has the client applied for new credit? Do you have letters of denial? So again, let's go back to the three issues. Increased out-of-pocket costs, loss of credit accounts, and denial of new credit. Those are the three kinds of damage to be considered in a credit damage claim. And the last thing, the most important thing you can tell your client is, don't throw these things away. They are the evidence that are going to be the foundation for your damage demand. The number one reason that credit damage demands are dismissed or laughed at, or even worse, is because there is no foundation for the amount. There are expert witnesses who will testify, yes, there have been violations of the law. Yes, there is a change, a negative change, an erosion of credit status on the part of the client. They won't tell you what it is, and they won't typically give you a value on it. The whole point of the demand is to get economic restitution. In order to get that, you must have a strong foundation that answers the 5 W's. And the documentation that will be generated by the client, as well as other sources, will answer: when did this happen? Who did it happen with? What was the amount involved? There's 2 more W's and I can't remember what they are. The 5 W's need to be answered. Who, what, when, where, why, and whatever the 5th one is. So those are the questions that all the documentation that will be put together needs to answer to the satisfaction of either the bench or a jury or opposing counsel. If you don't do it, you don't get any money. That's simple. I was talking to an arbitrator over lunch at a conference recently, and she said, very motivating to me, by the way, she said when she sees a credit damage demand included in a motion, is that the right word?
Oh, in a request for damage or
Yes.
statement of damages.
She throws it out because she says that in practicing for many years, I think she said 22 years, she's never seen a properly presented credit damage demand. If you follow this procedure and what I'm about to describe in a few moments, you will have a properly prepared credit damage demand. Because now I got to figure out what I'm going to say next. Okay? Is this Dana?
Yes.
Hi, Dana.
Hello there, how are you?
We've never met.
Nope, as a matter of fact, I've missed your other presentations, and each time I've been disappointed
By missing them or?
by missing them. And now I see that you give really practical information.
I try, yeah. There's not too much theory here. That's part of my problem is I just do it. It's difficult for me to explain.
Right, right.
I can actually give you some follow-up on some practical information. I'm representing, Dana, just so you know, I'm representing some contractors, I'm representing a woman who was defrauded by some building contractors. They made some credit purchases in my client's name.
Fraudulent, yes.
Yes, and so we're in litigation, and one of the 2 creditors that with your help, she had written to the creditors, and I followed up with someone. And one of them, Wells Fargo Bank, finally kicked back all of the money. They wrote back and said, basically, you were right. These people were wrong. We're exercising our rights under our contract with the contractors to take the money back and charge them for it. We're deleting all the credit references in the client's name.
Okay.
So
I tape all of this because I'm going to, go ahead.
Oh, well. Anyway, the contractors, after they got wind of the rebate,
Wells Fargo.
what Wells Fargo did, they filed a cross complaint against my client, adding the money that Wells Fargo had taken out of her name. They just said that she'd agreed to pay them that, and so now they're suing her for the money as though she had agreed to pay it originally, and they had never fraudulently charged it. So I filed an anti-SLAPP motion in response to the cross complaint, and we'll see what happens with it. I'm seeking to have their cross complaint dismissed because it's retaliatory for her success in petitioning for relief from their fraud.
Okay. Would you care to say a little bit more about our conversations, some of the suggestions that I made to you that were of use in this matter?
Well, that was, initially it was in regard to what to do about these two banks or creditors that were calling for money on these accounts that she hadn't created. And you gave me some information that the client actually used herself to write to the creditors to try and get them to, take care of the situation. And although she didn't get anywhere initially, I kind of used some of the same content in following up, and it sunk in eventually.
Lawyer letterhead does help.
Sometimes it does.
No, it helps.
Sometimes
It helps. So, is the case in midstream, or?
Yeah, it's still. We were actually scheduled to begin trial this month, and the other day the court continued until next month. But I don't really see how we can go quite yet with all, because they just filed their cross complaint. We haven't had the hearing yet on my anti-SLAPP motion. That's next week. And but in the meantime, we again with some help from you as to what her. Because she has a credit damage component here, and so I added that into the settlement demand when we were trying to mediate and get this thing resolved. It didn't work, but that wasn't because it didn't have anything to do with. I mean, it was helpful to have the credit damage information, but yeah, they, like most lawyers are still, they poo-poo it.
Well, remember that for, depending on how you want to count, either from 1899 or from 1970, the position of almost anybody who would have a financial obligation to pay such a demand vigorously and systematically spread the concept that credit damage is not measurable. I have proved them wrong. In 1995, I was the first person to prove them wrong. I do so regularly. Generally, for every 1,000 lawsuits filed that have a credit damage compensation aspect to it, 3 for every 1,000 has any sort of financial recognition of that credit damage demand, if you will. That's not a very high percentage. The cases that I get involved with have a 97% success rate. And that's because there's a proper foundation to the demand. There's the documentation you need, there's the answering the 5 W's that are necessary. It's like any aspect of your case. If you don't prepare it properly, it's not going to prevail. Credit damage has that same requirement. You must be properly prepared to explain and convince the listener, again, whether it's the judge or the defense counsel or opposing counsel or a jury. Juries are very sympathetic to credit damage demands. They're not universally sympathetic to it. If they smell that the plaintiff is trying to pull a fast one or going for phenomenal compensation because they got a splinter and they couldn't work, juries are not stupid. They understand that very well. If proper foundation is the key to success. And in a moment, I'm going to pick that up again, okay? All right?
Sure.
Now, what am I going to talk about next? Do you have any questions or comments?
Well, the reason why I'm here is because, well, there's a lot of arbitration and mediation. This month I have 3 for the state bar, attorney-client ones basically, and there's allegations not worded this way as credit damage, but having the same effect of saying, when you sued me for the fees, it ruined my credit, you owe me money. I got 3 of them coming up this month for the state bar.
Okay.
And they're not worded as credit damage,
Right.
but the gist of the pleadings is credit damage.
Is it safe to say reputation damage?
Yes, but they don't even use those fancy
Okay.
terms of art.
All right, I guess that's where I will start off next. Ready? Okay. Credit damage, credit injury, is a form of reputation damage. Loss of reputation is one of the most serious injuries an individual or a business can have. If your reputation stinks, your life is not going to be very good. If somebody has caused your reputation to suffer, that's what you're trying to be compensated for. It's not a lifetime compensation. It's a 7-year or 10-year compensation. It's not like you lost your arm, which can never regrow. It's that your reputation has suffered for a 7 to 10-year period, and that's the compensation you're entitled to. Because if you don't improve your credit reputation by either continuing or starting to pay your bills promptly, it's your fault. It's not the original causation's fault. There is a responsibility on the part of the individual. And I probably haven't said it, so let me say it. Any form of self-inflicted damage is not compensable. One of the most common, not common, but most common problems in a credit damage case is context. The context is that Mr. and Mrs. Jones ran up their credit cards because they had a lot of money, and something happened and their credit went bad, or they're accusing somebody of making their credit go bad, either collection inappropriately or denial inappropriately. And what is discovered is, through analysis of the credit report and analysis of the documents that I've mentioned before, is that their debt-to-income ratio is the problem. It's not their credit. 1 or 2 late pays is not going to kill your credit. When letters were used, ABC, as a credit rating, AAA or A-rated credit could have 2 late payments on it of any kind within a 2-year period. Things happen to people. The mail gets delayed, you're on vacation, you forget to send a check out. Lenders understand that. That's why when they were using the alpha designation, again of ABC, to determine a credit rank. And the other thing that is a misconception on the part of many consumers is that ordering your credit report will lower your credit score. That's absolutely not true. If you order your credit report every hour and a half or once a day for a long time, yes, you're going to impact your credit score for a variety of reasons. However, if you're going shopping, you're going to buy a car, you're going to buy a house, you're going to buy whatever it is, and you are offered credit by one company and you don't like it. You think you can get a better deal, and either that company says, well, I'll find you a better deal, or you find your own better deal, and you have 10, 15, 20, many inquiries in your credit report for that purpose within a 30-day period. All of that counts as one inquiry. So shop. It took the California Mortgage Bankers Association 6 years to convince the FICO company that people shop for the best deal. Well, that's part of the new credit score algorithm that is used to arrive at the number that is assigned to you. And that's probably what we should talk about next, is your credit score and what it does to your credit. Your credit score originally started back in the 50s, mid-50s, as a national risk score by the TRW Credit Information Services Company, which no longer exists, but has been replaced by the Experian Credit Information Services Company. Originally, what happened was, because credit reports were written in code, so that a lot of information could be packed into a minimum space. For instance, a typical subscriber credit report will be somewhere between 8 and 11 pages. A typical consumer disclosure report will be somewhere between 20 and 40 pages. So a lot more space is involved, a lot more paper is involved, a lot more reading is involved. Because of the codes, when you're decoding anything, you have to learn the codes. At that time, TRW was saying that in their experience in training their staff, it took 40 hours to learn to teach one of their new employees how to read a credit report efficiently. I'm not sure what efficiently means, but efficiently. And that was very expensive for the company, and the companies went back to TRW as well as the other two bureaus, which are TransUnion and Equifax. The Equifax report is published by the CBI Credit Bureau Incorporated company, which is the oldest credit bureau in the country. CBI started in 1899. So the creditors went to the credit bureaus, particularly TRW, and said, you got to give us a shortcut. You got to give us a way to realize who should have priority in the applications that we're processing, because we get 10,000 applications a day, and we're just getting overloaded, backed up, and it's very, very expensive. So TRW, with some other people, but they were the spearhead, came up with the National Risk Score. And what they said was, we are going to tell you which lenders, based on the information in their credit report, are the least likely to file bankruptcy. The higher the number, the less likely it is that they will file bankruptcy. The lenders loved it. And pretty quickly, the other bureaus had a similar service. And then, for reasons that are not relevant to this presentation, the accuracy of that prediction suffered. And several lawsuits were instigated against all three bureaus because the perception was that the scores were basically not much more indicative of the probability of bankruptcy than a wild guess. A couple of years passed, and the Fair Isaacs Company came on the scene. Computers were getting more and more sophisticated, and the Fair Isaacs Company, which has terrifically intelligent management, went to all three bureaus and said, we are better at computers than you are. If you will tell us what you want to put in your credit score, we will create the software for you. Whatever fits your picture or profile is what you will use. Call it whatever you want. Just use our software and pay us a royalty every time you run a credit score. And currently, I am told that the Fair Isaacs Company gets $2 every time a credit score is pulled. Now that doesn't sound like a lot of money until you realize how many hundreds of millions of credit reports are typically pulled in a year. So, Fair Isaacs was so savvy that they went to the federal government and got the federal government to violate their own rules. And the federal rules now say, if you're pulling a federal loan, you must have at least 2 credit reports with scores, FICO scores, in accompanying the application that you're going to submit to us. Now, government has a rule that says no single provider. They specified who you had to use. That's still the rule. Anyway, one of the changes that happened when FICO came in is that from an alpha ranking, ABCD, it became a numerical ranking, a 3-digit score. The 3-digit score is more precise in categorizing a borrower than a letter, because a letter is subject to interpretation. The number 3 is the number 3, no matter how you look at it. So it becomes very precise. What floats is what category that score will fit in. Now, in the 15 or 20 years that the Fair Isaacs Company has been around, there are 10 variations or revisions of the FICO scoring program. Everyone has been a little bit more consumer friendly. None of them is perfect for a variety of reasons. So if you're looking at a credit score of 2 or 3 years ago, you have to know which algorithm or which version of the Fair Isaacs software was used so that you can compare appropriately today's score with a different version of the modeling profile. The Fair Isaacs Company has been very, very secretive about what they do to arrive at their score, because they say that they are very concerned that people will manipulate the scores if they know how they are arrived at. Well, if you look at 10,000 credit reports, a pattern pretty quickly emerges. So a number of people have figured out what happens when a bankruptcy shows up on your credit report, what happens when a divorce shows up in your credit report, what happens when any legal notice, repossession, shows up on your credit report. To some degree of certainty, there's an ability to understand the change in score that particular activity will reflect in the change in the score. However, almost everyone has 5 scores. So when someone says to you, "What's your credit score?" that's a meaningless question, because each of the 3 credit bureaus that has a file on you has its own score for you. The Fair Isaacs Company offers you their own score for you. The reality is that only one score, and that's, in my opinion, the last score, is of any value whatsoever, and that score is the score that the company you apply to for credit has for you. Every other score is meaningless. Absolutely meaningless, because nobody else is giving you money. Nobody else is going to decide what to charge you, or if to charge you, or if you're acceptable. So get away from the concept that credit scores set your rate. They do not set your rate. They determine the priority with which your application will be accepted, if it's accepted at all, and or processed. At one point, not too long ago, Bank of America was in Orange County, California, was receiving 10,000 loan applications a day. That's why they needed to prioritize which application are we going to look at. So the need for credit reports and the need for credit scores has never been stronger and more cost-effective for the lenders. When a credit score is determined or set, be aware that it changes almost every day, because one of the factors that is absolutely involved in every version of the credit score is age. Among the known factors that influence your credit score, 35% of your score relates to how current your bills are. So 1/3 of your score, if you're late on bills, will drop. If your debt-to-income ratio is out of whack, not in an acceptable range, the Fair Isaacs score says that they can calculate that, but you can only know that accurately if you know the income of the individual. Credit reports don't have that information. What the credit reports and the Fair Isaacs Company do is they take your credit limits on your credit accounts and compare your balances to your credit limits, and if your credit limits are in an unacceptable ratio to your credit balances, your score drops. So if you have a $10,000 credit card and it's normal for you, hypothetically, to have a $5,000 debt against your $10,000 credit line, your score could be higher if you lower the debt ratio. So in that sense, you have the ability, the individual has the ability to manipulate their credit score. There are quite a few companies, a shrinking number, but still quite a few companies, that will not include your credit limit in their information provided to the credit bureaus or to the FICO company. So what happens in that situation is the score algorithm assumes that the amount that you owe is your credit limit. If you're at 100% of your credit limit, guess what that does to your credit score? Among the other factors that are not directly reported in your credit report are whether you're married, whether you have children, and other information, and somehow all of that is supposedly included in the calculation of your FICO or credit score. So there's a lot of voodoo going on in credit scores. The most important thing to know about your credit score is you can influence it, that anything that happens to you for your credit worthiness will affect your credit score. If you're not paying your bills, late payments show up. Late payments, again, are 35% of your credit score. If you want to know what the other percentages are, go to my website. They're all on there. How am I doing on time? I need 10 minutes? Oh, I've done 10 minutes, or I need 10 minutes? Okay. I could do this, till one of us falls asleep. All right, so to recap, your credit report is your credit reputation in print. People don't know each other anymore. We are such a mobile society, particularly in large cities, large communities, that the people you grew up with are not the people that you live with. You don't know your banker, you probably don't know your golfing buddy for more than a few years. There is no personal history on which they have a personal reputation opinion of you. So they must pull a credit report. That's another reason why credit reports are so popular. And credit reports not only affect your ability to borrow, they affect your ability to get a job. And in some states, your ability to get insurance. So the credit reports are very important and are a cornerstone, but not the only document that an expert would use to determine the damage value of your reputation as shown in your credit status, credit reputation status. Protect your credit. It's truly the most valuable piece of information you have in this society. Whether you're getting a divorce, whether you're looking for a job, whether you're going to start a business, whether you're getting out of a business, all of those footprints will be in your credit report. You cannot escape it. It's the big brother that everybody was afraid of. It's not the government, it's the credit bureaus. Okay? If I need to fill in, I'll fill it in a few minutes.
I have a question for you.
Go ahead.
I work with primarily bankruptcies,
Okay.
and there's a philosophy out there that I think is probably true, that when a person is justifiably and necessarily going into bankruptcy, their credit score is so bad, their debt to income ratio is so off, and their payment history is so late, that a bankruptcy virtually improves the score on occasion by changing the debt to income ratio and stopping the late payments.
It goes further than that. Okay?
Okay?
The law is that when one has a discharged bankruptcy, all the footprints, all the tracks leading up to the bankruptcy, the late payments, the debt to income ratio, all of those things are erased. Only thing that can be put in the accounts can be reported. But the balance can't be reported, the payment history can't be reported, so you literally get a fresh start. You not only get out from under the bills or the debt, financial obligation, you can tell anybody who needs to know, well, such and such happened. Whether it's true or not, the credit report will not tell on you. Okay? So it truly is a fresh start. It truly is I think in most cases, for people who go, by the way, the number one causation, I feel silly telling you this, the number one cause of bankruptcy, financial bankruptcy, is not credit cards. It's medical bills. Okay? So when they passed the Credit Card Act, when they changed the bankruptcy laws with the idea that people were getting out of their credit card accounts and they were stiffing the credit card companies, since the law that basically has not changed. It has changed in context to the change of the economy. The medical bills are still the number one problem. The percentage of bills in that bankruptcy is still about the same as it was for credit cards as before the change, the modification of the act. The credit card companies spent zillions of dollars and literally got nothing for their money. I'm curious as to what the effect will be on the new medical health program and what it will do for bankruptcies. Is there going to be a health care program where people will not have to file bankruptcy because of the amount of their bills? That's a sidebar, but that's, there it is. Anything? Anything else I can answer?
No, that, I think, well, let me ask you another question actually that I'm interested in. And you may not know the answer because this may not be the focus that you work within. Do certain credit extending agencies, meaning banks and lenders and people like that, do they, even though they're getting this credit report and they're getting this overall score, do they focus on certain kinds of debt that relate to the kind of credit they're likely to extend as far as the history, or is it just the whole debt picture?
The exception would, well, it depends on the reason for the application.
Okay,
If you're applying for a credit card, they want to know how many you have.
right,
If you're applying for real estate, they want to make sure you're not getting it over your head.
right.
Okay? So in that context, yes, they care about hypothetically, you have 50 credit cards already at $1 zillion each per card, and you're applying for another one just because you collect them as trophies. 25 years ago, you could do that. You can't do that today. Today, if you have a credit card with a high unused balance, they'll lower it automatically because they consider the unused portion of the credit a bomb waiting to go off and kick them in the bank account, okay? So I hope that answers your question.
It does. Basically, I think what you're telling me is they look at certain kinds of credit activities as it relates to the credit they're extending to see where you're at in the process, but they don't necessarily, if they're a mortgage company, look more closely at your mortgage history than your credit card history as it relates to late payments and timely payments and things like that.
It's too easy to look at a mortgage history because most people have 1 or 2 mortgages. There's not like you have 15 credit cards that have all kinds of variables in them.
Right.
If you're applying to a company for a real estate loan, they want to make sure that you have not caused a problem with a real estate loan, okay? If you're looking at a credit card, they want to make sure that you have enough discretionary income, that your debt-to-income ratio, your liquidity can support what you're asking for. I have a number of cases where I have walked away from the case because, in my opinion, the damage was self-inflicted. It was not, and the damage to the reputation was self-inflicted. And the other aspects of the case may or may not have been true, but there was such an overwhelming self-infliction of spending to drive up the debt. It was my impression that if they didn't win the case, they were going to file bankruptcy. And that was the plan. Hey, we win a lot of money, we're set. And if we don't, we'll just walk away from it. Yeah. So context is very important. And that's one of the other issues that comes up is, well, you know, we owed $1 zillion. Loan modification would be a very good example of what I'm talking about. Our house is worth $1, now it's worth 50 cents. I owe $3.50 on it. Okay? I'm going to walk away from it. There are some people who say that's unethical. I believe, personally, that in most cases, the contract for the $3.50 was unethical, and that pretty much neutralizes any objections to it.
Right.
Yeah, but in these credit reports, do you even consider basically you have a few hundred jumbo CDs stashed away, basically? Well, you're looking purely at income versus debt, not assets.
Asset is not a credit.
Okay, I'm saying, so it does not affect credit, no matter what it is.
Well, I wouldn't say no matter what it is. I would say that at the point of the ability to acquire that asset, the CDs, shows a capacity for credit that has been damaged, we'll assume, through the action that is the basis of my being there, okay? I just did a case for Bank of America in Mississippi, of all places. Mississippi was, the Bank of America in Mississippi were being sued by a couple who said that Bank of America, well, the story is this. The couple had a mortgage that they could have gotten a better rate on. They looked for a better rate. They found a better rate with Bank of America. Bank of America liked everything they saw in their application. They said, yes, we're going to refinance your house for you, and here's the check to the escrow company to pay off your first mortgage. What's interesting is the office that took the escrow funds disappeared with several $1 million. In doing that, they never paid off the first mortgage. So the first mortgage holder said, hey, you're defaulting on your loan. We're going to sue you. And even though it was at the higher rate, the couple that was in the house took the position that Bank of America had not issued the funds, and so they were still on the hook for the mortgage that they started with, and they kept paying that mortgage, and they sued Bank of America for breach of contract or whatever the right language is. I thought that was very interesting. So, two experts, 20, 30-page reports talking about how they'd been abused, what wonderful people they were, they walked on water, etc., etc. They did everything they could to violate the position of an expert, because an expert is supposed to be neutral, not an advocate. That was the first strike against that expert, to both of them. The second strike against their expert is that they based their entire premise of misconduct on consumer disclosure reports, not subscriber reports. And so in my rebuttal against these experts, my first was they crossed the line, and the second was there is no foundation for this claim. Because show me in your demand what the lenders saw on which they based their decision and how it changed. Guess who settled very quickly? The plaintiff, because they knew they didn't have a proper, they may have had a great case, but they didn't present it properly. So, presentation, as I said before, answer the 5 W's and answer them on solid information, not speculative or illusionary information. And I'm done. He's waiting
Thank you
at me,
very
so I'm
much.
done. Okay?
Thank you very much.
Is that okay?
It was great.
I mean, you've heard it twice now.
Yeah, but you know, there's things that pick up like, I have a case now that I just realized, I don't have a personal injury cases, but I'm working on a case where this person's been injured, she's going to be out of work a lot more than 4 weeks. And so now I just realized I've been writing to the insurance company's lawyers right now, and so credit damage will certainly get a reference.
Good, good.
Thank you.
We'll try and promote you more.